IT0366 PT, the prosecutor versus Vladimir Limaj, Haradin Bala, and Isaac Musliu.
May I have the appearances? Prosecution first.
May it please your honours, my name is Andrew Kelly. I appear on behalf of the prosecutor with my colleagues to my right, Mr. Alex Whiting, and to his right, Colin Black, and our case manager to my left, Mr. Hassan Yunus.
Thank you. And for the defence, perhaps first, Mr. Limaj, counsel for Mr. Limaj.
If it please your honours, Kareem Khan for Fatemir Limaj.
Thank you, Mr. Khan. And defence for Mr. Bala.
Good afternoon, Your Honours. Peter Murphy on behalf of Mr. Bala.
Thank you for Mr. Musliu.
Good afternoon, Your Honours. Stephen Poles for Isaac Musliu.
Thank you very much. I didn't say good afternoon to all of you yet, but now at least I know to whom I'm saying good afternoon. We are here this afternoon because the indictment against Mr. Limaj, Mr. Bala, Mr. Musliu has been amended, and therefore, in accordance with Rule 50B, we need a further appearance so that the accused can enter a plea on any new charges. Am I well informed that the defense does not insist on reading the whole of the new indictment, and is that true for all of the three accused?
Yes, on behalf of all three accused, Your Honour, that is the case.
Yes. But even if I don't have to read it all out, nevertheless it should be clear what new charges there are. So therefore I'd like to go more or less first systematically through all the amendments in the indictment, and then later on I'll invite the three accused to enter pleas on the relevant parts. The first amendment relevant for all three of the accused is the inclusion of a new count 5. Count 5 relates to the factual description in paragraphs 25 and 26 of the new amended indictment, in which, just to say it briefly, the conditions are described in which the detainees were held in Limaj prison, and count 5 adds to the counts 3, count 4, and count 6, in which this way of keeping detainees in Limaj prison was legally described as torture, crime against humanity. That was already in the indictment. Torture as a war crime was also already in the indictment. Cruel treatment as a war crime was already in the indictment. And in count 5, now there's a new legal qualification for these events, describing them as crimes against humanity through inhumane acts. So that's new as far as count 5 is concerned. Then the individual criminal responsibility, and I now move to my next point, is now in a new indictment also described for each of the three accused as participation in a joint criminal enterprise. That covers all the charges. That means charges 1 up to 8 included for all accused, and charges 9 and 10 also for Mr. Limaj and Mr. Bala. This joint criminal enterprise is described in more general terms in the amended indictment in the paragraphs 7, 8 and 9. And then the contribution of Mr. Limaj to this joint criminal enterprise is more specifically described in paragraph 10. The contribution of Mr. Musliu to this joint criminal enterprise is described in paragraph 11, and the contribution of Mr. Bala to the joint criminal enterprise is described in paragraph 12 of the amended indictment, whereas we find some mens rea aspects of this joint criminal enterprise for all three accused together in paragraph 13 of the amended indictment. Then the amendment also deals with the counts 7 and 8. Count 7 and 8, charging the accused with murder under 7 as a crime against humanity, and under count 8 as a war crime. What has been changed is that a new victim of murder has been added in paragraph 29 of the amended indictment. That is Mr. Ajit Kashi, who is newly introduced, and Mr. Limaj and Mr. Musliu are charged with command responsibility for this murder, whereas Mr. Musliu is also charged for the participation or aiding and abetting in the murder of Ajit Kashi. Apart from that, some changes have been made in the annexes 1 and 2, both under counts 7 and 8, where new names appear as victims. In Annex 1, it now reads that Slobodan, also known as Boban Mitrovic, was a victim, and that Sinisa Blagojevic was a victim. Whereas in Annex 2, we find two new names, Jefta Petkovic and Zvonka Marinkovic, as new names as victims of murder under count 7 and 8. Other names do not appear or do not appear anymore in exactly the same way in these annexes. And of course, charges in respect of these other names then do not exist anymore, have been dropped. I just mentioned that Annex 1 does not concern Mr. Bala, but Mr. Bala is concerned by Annex 2. Another change is that Mr. Musliu is now held responsible in this amended indictment for the counts 1 up till 8 included, not only on the basis of Article 7.1, individual criminal responsibility, but also is also held responsible by the prosecution for, under Article 7.3 of the statute, commands responsibility. Then some details have been changed in the indictment in paragraphs 1 and 2 and 5. These changes do not specifically ask for a new plea, but I just draw your attention to that. These are, in short, the amendments to the indictment. Before we continue, could I ask you whether you would agree with this short summary of the amendments in the indictment, whether I've forgotten anything or whether I said too much? Yes, Mr. Kelly.
Your Honour, I think that's an accurate and succinct version of the new indictment, the amendments in the second amended indictment.
Thank you. Any comment from the defence of any of the accused?
Your Honour, on behalf of all three of us, we concur.
Yes, thank you very much. Then I'd like to ask each of the accused first whether they have, together with their counsel, carefully read the amendments and whether they've carefully read the new indictment as it stands. Could I first ask you, Mr. Limaj, whether you are fully aware of the changes in the indictment? I'm not asking you to enter a plea yet, but
Åzotri gjyqtarë e kemi kuptuar në gjyqimet në akt akues. Meqense ka mungesë të disa emrat e citativi cekët neve nuk ka ofruar realist.
I'm sorry to interrupt, Your Honour. We're not getting an English translation.
yes, neither do we. Could we see that the English translation? I expected it on Channel 4, as a matter of fact, but should I change channel or? Oh, the microphone is not on. Yes. If perhaps the security officers.
Your Honor, they are checking it. The technical
Yes. Yes.
people are checking.
Can I start?
Could you speak a few words, Mr. Limaj, so that we can see whether we receive your...
Siç thash,
As I said,
të gjyqtar pjesën
Your Honour, we've understood most of the new indictment, but there are names missing from the lists of victims, and we continue to have problems with documents that have arrived changed from the prosecutor's office, and we are not being supplied with full list of names of these so-called victims that are laid at our door.
Let me stop you here. I'm also looking at counsel. People not appearing on a list of victims, Annex 1 or Annex 2, are not within the scope of the indictment. So if there have been other victims, but they are not named, then you're not charged with any criminal responsibility for whatever has happened to those victims, or at least those persons. So that's something which has nothing to do with understanding the indictment as it stands after being amended.
I don't know how far you understood me. I say we don't have the complete list of the added names. Them we've heard for the first time here today.
Well, as a matter of fact, I think the annexes were part of the new indictment. May I ask counsel whether there's any problem in respect of...
Your Honour, no. The names have been part of the amended indictment. Your Honour, perhaps if you give me a moment to speak to my client.
Yes, if you would like to consult with Mr. Limaj, please go ahead.
Your Honour, I don't think there's a problem, but perhaps if you give my learned friend also one moment.
Yes.
I'm grateful, and I think it's been clarified.
Then, Mr. Limaj, I would again ask you whether, after having consulted with counsel, whether everything's clear to you what has been amended in the indictment, and whether you thoroughly studied it and discussed it with counsel.
Yes, Your Honour.
Thank you. Then, Mr. Bala, I would have the same question for you.
Yes, Your Honour, I've just talked to the lawyer.
And everything's clear to you now as well?
Yes.
Thank you. Then, Mr. Musliu, I'd like to ask you also whether you went through the amended indictment with counsel and whether you understand what the changes are, especially in respect, especially compared to the indictment on which you have already entered a plea.
Yes, Your Honour. I have analysed and looked at all these things, and these changes to the indictment are clear to me.
Thank you very much, Mr. Musliu. Then I'll now go through the amendments of the indictment again, and I'll invite you to enter a plea on any new charge brought against you under the amended indictment. First of all, I draw your attention.
Sapari, doet u te hech vermendian.
I now get a language I do not understand. I'd first like to take all three of you to new count 5, in which the way you allegedly detained person in Lapushnik prison is now also legally qualified as inhumane acts, a crime against humanity. May I first ask you, Mr. Limaj, after you've listened to my reading of the new count 5, count 5, which reads, inhumane acts, a crime against humanity, punishable under Article 5.1 7.1 and 7.3 of the statute of the tribunal. How do you plead to count 5?
We've already declared our plea even earlier, and even now we do not accept that. Let's say, me personally, I do not accept that such a camp has existed, and as a result...
Let me stop you. Whether you're guilty or not, whether you accept the charge is a different matter, which will come up at trial. The prosecution will have to prove the charges. The only thing I want to know from you at this very moment is how you plead to this new count 5, inhumane acts, a crime against humanity. Do you plead guilty or not guilty?
Not guilty, completely.
Madam Magistrate, the new non-guilty plea on count 5 should be put on record. Then may I ask you, Mr. Musliu, I again read count 5 to you. Inhumane acts, a crime against humanity, punishable under Article 5I and 7.1 and 7.3 of the statute of the tribunal. Do you plead guilty or not guilty to that new count?
Not guilty.
Thank you, Mr. Musliu. Madam Magistrate, would you please record the non-guilty plea of Mr. Musliu to count 5? Then Mr. Bala. You're now charged under count 5 with inhumane acts, a crime against humanity, punishable under Articles 5I, 7.1 of the statute of the tribunal. How do you plead to this count? Guilty or not guilty?
Not guilty.
Thank you, Mr. Bala. Then we move to the next amendment of the indictment, which is the introduction of criminal responsibility under Article 7.1 through a joint criminal enterprise. As described in general terms, paragraph 7 to 9 of the amended indictment, and for you, Mr. Limaj, specifically in paragraph 10 of the amended indictment, and in respect of the mens rea aspects also in paragraph 13. There is no new count. It relates to all counts you're charged with. That means counts 1 up till 10, criminal responsibility, also in the form of a joint criminal enterprise. How do you plead to this criminal responsibility you're charged with now? Guilty or not guilty?
Not guilty entirely.
Madam Magistrate, would you please record the non-guilty plea of Mr. Limaj on the joint criminal enterprise on all charges 1 to 10. Then Mr. Musliu. You're now charged also with criminal responsibility through a joint criminal enterprise on all the charges relevant for you. It is 1 up to 8, 8 included. This joint criminal enterprise is described in more general terms in the paragraphs 7 to 9 of the amended indictment, and your contribution to it is described more specifically in paragraph 11 and mens rea aspects in paragraph 13. How do you plead to this charge, which charges you also with joint criminal enterprise responsibility under Article 7.1 of the statute for all these 8 counts? Guilty or not guilty?
Not guilty, of course.
Thank you, Mr. Musio. Madam Registrar, would you please record the non-guilty plea on the joint criminal enterprise on counts 1 to 8, entered by Mr. Musliu. Mr. Balla, you're also charged with, under Article 7.1, with a joint criminal enterprise, and you may have heard already that it's in general terms described in the paragraph 7 to 9 of the indictment. Your specific contribution is described in paragraph 12 of the indictment and the mens rea aspects in paragraph 13. How do you plead to this charge of being criminally responsible through a joint criminal enterprise on all counts 1 to 10? Guilty or not guilty?
Not guilty entirely.
Madam Registrar, would you please record the non-guilty plea on the joint criminal enterprise form of criminal responsibility on the counts 1 to 10? Then I move to the next amendment, which is the murder charges, both as crimes against humanity and as a war crime, under counts 7 and 8, where Ajit Gashi in paragraph 29 of the amended indictment is added as, or is introduced as a victim, and where names are added to the annexes 1 and 2 to the indictment on the existing murder charges. Mr. Limaj, on the murder charges in counts 7 and 8, and I'll read them to you. Count 7, murder, a crime against humanity, punishable under Article 5A, 7.1 and 7.3, with the new names Ajagashi added and the changes in the annexes 1 and 2. How do you plead to counts 7 and count 8?
Not guilty, of course.
Madam Registrar, would you please record the non-guilty plea on the counts 7 and 8 with the new name of a victim in paragraph 29 of the amended indictment, and new names or names changed in the annexes 1 and 2 to the indictment. Mr. Musliu. I also read to you the counts 7 and 8, murder, a crime against humanity, punishable under Articles 5A, 7.1 of the Statute of the Tribunal, and murder, a violation of the laws or customs of war as recognized by Common Article 3A1 of the Geneva Conventions of 1949, punishable under Article 3, 7.1 and 7.3 of the Statute of the Tribunal. In view of the name of Mr. Gashi added and the changes in the annexes 1 and 2, on which now appear new names of victims, how do you plead to count 7 and count 8?
Not guilty.
Madam Registrar, would you please record the non-guilty plea of Mr. Musliu on the counts 7 and 8 as they appear in the amended indictment? Mr. Limaj, I'm afraid that I have not been complete in reading the counts, but correct me if I'm wrong. I think I did not read out count 8 to you. I'll do that now because I earlier read to you murder as a crime against humanity, but I did not yet read out to you murder, a violation of the laws of customs of war, as recognized by Common Article 3(1)(a) of the Geneva Conventions of 1949, punishable under Articles 3, 7(1), and 7(3) of the Statute of the Tribunal. When you pleaded guilty to count 8, did you understand this to be the content of count 8?
Your Honour, not guilty, of course.
Not guilty, of course.
I'm sorry if I made a... Yes, I said when you pleaded, that's what I said. At least that's what the transcript says. When you pleaded to count 8, did you understand this to be the content of count 8? And of course, I noticed that it's even on the record, that Mr. Limaj pleaded not guilty on it. So it's just a matter of verifying whether his understanding of count 8 was complete and correct.
Your Honour, I do apologise. I see what's on the transcript, but I seem to have heard, perhaps it's my mistake, that you did say guilty, but I don't take it any further.
That's, I thought that I'd chosen my words carefully, but I cannot guarantee that I did not make a mistake. Mr. Limaj, please be seated. Then Mr. Bala. I will also read count 7 and 8 to you. That is count 7, murder, a crime against humanity, punishable under Articles 5(a), 7 and 7(1) of the Statute of the Tribunal, and count 8, murder, a violation of the laws and customs of war, as recognized by Common Article 3(1)(a) of the Geneva Conventions of 1949, punishable under Articles 3 and 7(1) of the Statute of the Tribunal. As far as it concerns you, Mr. Bala, you're not charged with the additional name of Mr. Gashi in 29, which is limited to Mr. Limaj and Mr. Musliu, if I well understand the indictment, Mr. Cayley. You are also not charged with murders of persons named in Annex 1, but you are charged with murder in relation to persons mentioned in Annex 2 to the indictment, in which also 2 new names appear. How do you plead on counts 7 and 8?
Not guilty. Not guilty.
Thank you, Mr. Bala. Please be seated. Madam Registrar, would you please record the non-guilty plea of Mr. Bala under the new a new amended indictment, including different and new names of persons mentioned as victims of these killings. Then, finally, Mr. Musliu, in respect of you, the indictment has been amended, as I indicated before, to the extent that on all counts, that is for you the counts 1 up till 8, 8 included, you're not only held responsible by the prosecution for your individual criminal responsibility under Article 7(1) of the statute of the tribunal, which today has been extended also to joint criminal enterprise under Article 7(1), but also under Article 7(3), that is on the basis of command responsibility. How do you plead to the counts 1 and 8, 1 up till 8, 8 included, on the basis of Article 7(3) of the statute, that is as responsible as in your command position? Do you plead guilty or not guilty?
Not guilty.
Thank you, Mr. Musliu. Madam Registrar, would you please record the non-guilty plea of Mr. Musliu for responsibility under Article 7(3) on all counts relevant for him, that is counts 1 to 8, 8 included. We have now recorded the pleas of all accused on all new charges or all relevantly changed charges as they appear in the Second Amended Indictment. Is there anything at this moment in respect of this subject that the parties would like to raise? As the parties may be aware of, there will be a status conference after this initial hearing. Is there anything to be raised? I see nodding no from the defense, Mr. Kelly. Then we stand adjourned, and the status conference by the pretrial judge, Judge Carnival, will start soon.
All rise, veuillez vous lever. All rise, veuillez vous lever. The International Criminal Tribunal for the former Yugoslavia is now in session. L'audience du tribunal pénal international pour l'ex-Yougoslavie est ouverte. Please be seated.
Good afternoon again, ladies and gentlemen. May we have called the case, Madam Registrar, please.
Good afternoon, Your Honor. Case number IT 0366 PT, the prosecutor versus Vatmir Limaj, Haradin Bala, and Isaac Musliu.
Thank you, Madam Registrar. May we have the appearances for the prosecutor?
Yes, may it please Your Honour, my name is Cayley. I appear on behalf of the prosecutor with my colleagues, Mr. Whiting to my right, to his right, Mr. Colin Black, and to my left, the case manager, Mr. Hassan Yunus.
Thank you, Mr. Cayley. And for the defences, please.
Your Honour, Kareem Khan for Vatmir Limaj.
Peter Murphy for Haradin Bala, Your Honour.
Your Honour, Stephen Poles for Mr. Isaac Musliu.
Thank you very much.
And if I may, while I'm on my feet, raise one matter, and that's in relation to interpretation on behalf of Mr. Mushliu. I understand from the previous hearing that there were some difficulties with translation from English.
Yes.
And there were some difficulties with at least one of the interpreters, perhaps just an accent problem, but not the entirety of everything that was said
Yes.
was understood, certainly by Mr. Mushliu.
Well, I suppose that the translator has already, interpreters have already heard what you have said, and they will take due care for that. Please, thank you. Mr. Bella, please, would you stand up? I would like to be sure that you understand what is said in a language that you know.
Yes, although I did have problems with the interpretation.
Yes, if you had problems with interpretation, please tell us immediately, and we'll try to find and to ease for you the problem. So?
It was merely a technical problem, but some of the things I didn't manage to understand.
Perhaps if you get some changes to the material and chemical appliances that you are using would be easier for you. I don't know. I should ask to the technicians if that is a possibility. Well,
it's a matter of the pronunciation of the interpreter.
Oh, I see. Well, perhaps another one will take up that perhaps uses an accent that is more understandable to you than others. You know that everybody will have different accents, speaking languages, and that's probably a problem. Okay, if you have some problem, I see that your counsel is also trying to ask about that. You had any problem? Mr. Murphy, please.
Your Honour, yes, if I may assist, I understand that there were two interpreters involved during the plea hearing, a man and a woman. My understanding is that Mr. Bala had no problem with the woman interpreter, but the difficulty of accent arose in relation to the man's interpretation.
So I will address myself to the interpreters if you can solve the problem that is had by Mr. Ballard, so only temporarily if you have this problem. I hope you haven't had a problem with the previous appearance for the pleadings that you had been asked. You had understood completely whatever has been said before. I mean, in the previous appearance, you have.
Yes.
Well, thank you. You may sit down. Please, Mr. Limaj. Do you understand whatever is said here? And you understand the proceedings without any problem in a language that you can understand completely?
Yes, I was, Your Honour.
Thank you. You may sit down. And then Mr. Musliu, please. I have to ask you the same question. You have understood and you understand now whatever is said at this moment in this occasion perfectly all right in a language that you understand?
Regarding the changes in the indictment that we discussed earlier, they in general are clear to me. But as for the interpretation, it's the interpreter who does not speak in his mother tongue and has had some problems in some matters, but in general I have understood.
Yes, but I am not speaking of the previous appearance, but now, at this moment, you understand what I am saying and what everybody here is saying, so that you don't have any problem to understand whatever is being done at this moment?
Momentan is dat een regel.
At the moment, everything's all right, and I understand the interpretation.
Thank you very much. You may sit down also. Well, I had some good news, if I may say so, from you all about how the preparation for the trial is faring. So I would encourage you to keep in the same path you had already taken. First of all, if I had well understood, your case is going to be ready for trial at the end of June. That is very important because, as you have been told, there are at this very moment quite a few cases that are at the same point of the proceedings, and it's important to be ready to be selected by Mr. President of the Tribunal whenever another court will be free to take up this case. So I have been told that it's going to be most likely ready at the end of June, and that's, I would say, that's what was news. In order to accomplish this schedule, I know that the prosecution has shown his disposition to present the pre-trial brief today, and I suppose nothing has going to prevent you of doing so.
Your Honour, I mean, do you want me to run through very briefly where we are, or would that assist the court?
Yes, of course.
We will be disclosing our pre-trial brief today. Part of it, the main component of that brief, is a public document. Part of it is confidential. That will be filed with the registry today, but in order to assist the defence, we're going to provide them with a courtesy copy today that they can take away with them. A couple of other matters that arose out of the 65-ter conference yesterday, which I can deal with now. They are, firstly, the defence yesterday asked us for disclosure in both hard copy paper and also on compact disc. Previously, they had asked for us only to give it to them in the form of compact disc. Prior to that, we were giving it in hard copy. We will give them both in order to assist them with their preparation. They can have the disclosure both in paper and on compact disc on CD. We will also be giving them today a copy of what is in fact titled a virtual reality, but Mr. Murphy's already pointed out the shortcomings of that title. It's essentially a 360-degree presentation of the locus in quo, the place in question where the alleged crimes took place. That has all of the software on it so that each of the defence counsel can run that on their own computers, and it also has an instruction manual with it, so they'll be able to take a copy of that away with them today. Mr. Murphy also asked a number of questions of us that were outstanding that we hadn't answered in the letter, and we have in fact put together a letter today covering all the points that he raised in the 65-ter conference, and we will give a copy of that letter to each of the counsel for the accused today. Lastly, my understanding at the 65-ter conference yesterday, and you will have read this yourself, is that the agreement is that the defence will file their response to our pre-trial brief by the 10th of May of 2004. That was agreed by all the parties. And in respect of the expert reports, it was agreed that all of them, apart from one, the defence would respond under 94 bis again by the 10th of May of 2004, and that was agreed between the parties. There is one outstanding report, the historical expert. For reasons of illness, our original expert was unable to give evidence, and so we've had to replace that individual at short notice. And that report will be filed in May or June, and we would ask for a response from the defence 30 days thereafter in accordance with the rules. So that's where I think we are at the moment, Your Honour.
Thank you, Mr. Kelly. That was also my understanding of the situation, but I want to take the occasion now to ask the counsels for the defense if they have some view that differs from that expressed by the representative of the prosecutor. So please stand up and speak if you feel that you need to make some clarification about what is being
Your Honour,
said.
yes, if I may, and that's in relation to the defence pre-trial brief being filed on the 10th of May 2004. As Your Honour heard, the prosecution may not be in a position to serve the report of the historical expert that they intend to rely on until either May or June of this year, which will of course potentially be after the filing of the pre-trial brief by
Yes,
the
excuse
defence.
me for interrupting, but if I've well understood, it seems that for this last fifth expert report,
Yes.
it's intended that, whenever it's being presented,
Yes.
you'll have the 30 days to answer whatever
Yes.
is said there. So, with the exception of this expert report,
Yes.
for all the other things, you are in agreement what has been recently said by Mr. Kelly for the prosecution.
You want to know, and my concern is this, and that's the filing of the pre-trial defence brief on the 10th of May, because that may fall clearly before the filing of the expert reports by the historical expert. My concern is that evidence may not be unimportant for this case. The historical evidence could, I don't know, not having seen it, could be of great importance to this case. And it's for that reason that it seems to me that it would make more sense for that evidence to be served on the defence prior to the service of a pre-trial brief on the 10th of May. Now, there may be two possible solutions to that. I don't know whether the prosecution will be in a position to perhaps bring forward their anticipated date for service of the historical report. If not, I really merely flag up at this stage my concern about filing a pre-trial brief in the absence of potentially important prosecution evidence.
Well, I understand what you mean, but it takes the situation back at before what was agreed on in the last 65 term meeting.
Well, yes.
So let's think that, let's put it this way. In any case, if you find that with the results of the other experts' reports, that's third and fourth, because the other two experts
Yes.
had already been handed down to you, and you can write your trial brief, your pre-trial brief. You are going to keep this date of the 10 May. In case there is not any possibility, because what is expected from the fifth expert report prevent you to maintain this line, well, I invite you, the parties, to speak again and to make talks between yourselves and try to find a solution, because what is not acceptable, I may say, is that the case won't be ready at the end of June. You had insisted, I know the counsel for the defense, you had insisted that some changes in the indictment would determine prejudice for your clients, because that could put the situation they could determine a delay in the trying of the case. So I agree that you are in very good will to keep the deadlines as much as possible. It is. So I understand what is your difficulty, but I nevertheless insist to you to try to do the best to maintain the deadline. That for the other counsel, is any problem?
Your Honour, just before that, may I assure the court that certainly on behalf of Mr. Mushliu, every effort will be made to have the case ready as soon as possible. My only point in raising my concerns in relation to the historical expert is that it's my understanding that that evidence may not be unimportant. And if that evidence is not going to be served until the end of June, that could present difficulties for the preparation of the defence case. And my reason for raising it now is so that if the prosecution can do anything to bring forward the date for the disclosure of that evidence, I'd invite them to seriously consider that course.
But of course, I have, please, Mr. Cayley, I understand that you are all the same stance that is said by the Council of Defence, so please tell me.
Your Honour, first of all, we will do everything we can to get this report to the defence as soon as humanly possible. But I would add here, this is contextual evidence. It does not touch upon the direct crimes alleged in the indictment. It doesn't affect the principal allegations that we make against the accused. The evidence that the three defence counsel have now and will be given to them today set out the case against their clients. That particular evidence is not going to affect the position of my learned friends in their own pre-trial brief. That I can assure them of. Maybe in a very minor manner, but by and large, this is not evidence directly relevant to the crimes that we charge in this indictment. I'd also point out that the Rule 65 terse summary, which is attached to the pre-trial brief, we have to give a summary of all of the witnesses, actually outlines the evidence of this witness, so they can actually see from that exactly what this witness will be testifying about, exactly what the contents of the report will be. So I don't think it does need to be a matter that actually delays the filing of the defence pre-trial brief. I think May the 10th is a very fair date for both parties, and I would ask actually, Your Honour, that an order be put in place that the defence file their response to our pre-trial brief on the 10th of May of 2004.
Thank you, Mr. Cayley. You had heard, Mr. Paulus, what has been said by the representative of the prosecutor. So the only thing I can add to that is that if he is right and the case is not going to be so much influenced by whatever may be said laterly by the expert, the historical expert, I would encourage you to try to maintain the deadline. If ever you find such problem that what has been promised to you by Mr. Cayley, you don't reach, whatever is you expect to have to make your trial brief, please speak up and try to connect with him and try to ease out the situation.
I can assure the court that every effort will be made to meet that deadline.
Thank you very much. What about the other counsels?
Your Honour, we don't anticipate on behalf of Mr. Bala there being any difficulty in filing pre-trial brief by the 10th of May, regardless of the expert's opinion. The difficulty that may arise is this. Certainly in other trials before this tribunal, the testimony of historical experts has been a little more than contextual. It can, of course, have relevance to certain legal issues that the prosecution have undertaken the burden of proof. And it may be that that will be clarified when we see the 65 terse summary. I do see a possibility, however, that if the witness statement and any exhibits of this witness are not to be delivered to us until perhaps sometime in June, at that point the defense would obviously have to prepare a cross-examination, instruct an expert witness, possibly on the defense side. I'm just concerned about the trial date, and obviously this is something we can't really say for certain at this time. I would just like to put on record that depending upon the legal relevance of this evidence, it could possibly impact the readiness of the defense, certainly if we were to go on the 1st of July. We don't know that now, but I think it would be remiss of me not to bring that possibility to the court's attention.
See that basically your problem is the same as that of Mr. Paulus, so I would also encourage you to try to maintain the deadline that has been fixed. And in case the news that you can predict or can imagine that be included in the historical expert that could change your view of the case occur, you speak up also, try to connect with the prosecutor, and necessarily you need, you apply to me, and we'll try to find a way to ease out the situation. Okay?
Well, thank you. I'm most grateful.
And Mr. Khan, please.
Your Honour, I'm grateful. In fact, I express similar concerns to those outlined by my two learned friends. If I may say so, Your Honour, I think your proposal is eminently reasonable. We will work forward to the 10th of May date. Hopefully in the 4 months between now and June, the expert hopefully will be able to produce a report before the 10th of May, particularly if a summary already has been prepared that the prosecution have, and we will remain in contact. But if there are difficulties that we consider may prejudice our clients or prejudice the contents of the pre-trial briefs, we will of course let you, your senior legal officer, to Chambers and the prosecution know. Your Honour, on a second matter, I would like to record my thanks to the prosecution for their courtesy in agreeing to provide copies both electronically and in hard copies. It is a very laborious task, and it makes our life much easier to have them in both formats, so I am very grateful for that. The final point, Your Honour, is I think yesterday it's a very small clarification. I think it was anticipated that the trial date probably would be starting on or around the 1st of September, but it definitely would not start before July. And that's the timescale, of course, we are working to. It doesn't affect the pre-trial brief, but of course, in the context of the whole trial preparation, I thought that clarification ought to be brought once again to your attention.
Thank you, Mr. Khan. I thank you for what you have said, but let me tell you that don't confide too much on the 2 months, July, August. If it's absolutely necessary, we'll have to give way to and not to maintain and to keep no, please, you may sit down, to keep the deadlines that have been already fixed. So, but that should be something that could be the less possible possibility to say that. So let's try to keep the lines. If ever you had the same problem that you had told that you share with your other councils, please try to make me know, and we'll try to find a solution. But don't be very happy about having July and August, because, you know, August is probably a month that everywhere in the world, the courts, I mean, August or the equivalent to August in other regions of the world, are moments in which the work of the tribunals stop. So it could be better if we can be ready at the beginning of July, because this way we'd be already in the position of being considered by the president of the tribunal as one alternative to going on with the trial. So I thank you for whatever you have said. There is another point that I was going to mention, those points that you had already mentioned in both parties, but this is another point which is in reference with the 3 sets of agreed facts that have been conveyed from the prosecutor to the counsels of the defense. It could be interesting that you will keep in connection both the counsels for the defense and the prosecution, so as to find out a solution for this point. That is the last point I would like to mention in this meeting. There is also another. I have been told that you have not answered, none of you, the counsels for the defense, to some proposals by the prosecution of some witness statements to be received through the system of the Article 92 bis, the Rule 92 bis of the Rules of Procedure. So seems that the prosecution is intended to perhaps make some petition on this matter or some request, but I would advise you before the prosecution is introducing such requests to meet yourselves again and try to find out a solution for that, if that is possible. Now I have to, excuse me.
Your Honour, just on that one issue, Your Honour, I have repeated it on many occasions from the beginning, the initial 65 Turk conference, that of course it is our intention to confine the facts and issue to those really that we do dispute, and matters that can be agreed will be agreed. But as I made clear, I hope yesterday, and as well as the first 65 Turk conference, it is my position that the timing is premature to agree any facts or any statements until the prosecution have completed their disclosure, because one sees it all the time that seemingly innocuous facts may become actually facts and issue depending upon what other witness statements say. Yes. But Your Honour, of course you have our assurance that we will seek to confine the facts in dispute to those really that we can't agree. But other matters, of course, we will agree, and some statements no doubt can be read.
I understand what you say, Mr. Khan, but I am confident that your goodwill of all the parties could make for a solution of these problems. So as soon as the possibility of agreeing or answering about the question of the 20 witnesses that would be only whose testimony would be only through the 22nd bis rule of the rules of procedure would be ready. You'll be also ready to comply with what is expected from you also.
Your Honor, of course.
So I am very confident about that, and I am sure that it will work out. Okay, I want to go now to the accused. And Mr. Bala, please, would you have any problems about your the present situation in detention? You have facilities to communicate with your lawyer. You have some new, you want to know something that you haven't had so far clear enough on your case, on your situation, and also what is your health? You have any problem? I know that you had some problems because you were told you smoked too much, as I remember well. So please tell me just precisely the purpose of this status conference is that you can speak to the judges and tell us whatever you feel that is necessary for you to be known. Please.
Thank you, Your Honour. Everything is in order. I don't have any criticisms, and all the conditions of my custody are in order, and I have everything that I need. Thank you.
Thank you. You may sit down. Please, Mr. Limaj. I address you with the same questions. You have everything you need to be in health in your situation in the detention unit. You had the possibilities to consult and to speak with your lawyer, and the situation of your case is sufficiently well known to you that you can follow properly whatever is your problems now.
Mendoni?
As I said at the in the first session, there's no doubt that everything is in order, and my contacts with my lawyers are fine, and the conditions are fine, and in general, I'm satisfied.
Thank you very much. And Mr. Musliu, please, I address you the same question that I had made before to your colleagues. Your situation is all right. You can endure the position in which you are. Your health is well taken care of. You don't have any problems to contact with your lawyers. You have sufficient interpreters for whatever you need to communicate. Tell me, please.
Everything's in order. Everything is fine. According to the things, all the things that you mention are in order. Everything is okay.
Thank you. Please sit down. I have heard about the problem you have, all the three of you, about the way you are taken from the detention unit to here. That is really not very agreeable, I understand. In the previous status meeting, status conference, I asked the registrar to take care of that. I have to repeat again this to the registrar. I know that by the registrar has been taken care and has been intended to ease out all these problems, which I want you to understand that are not due to this tribunal, but that's because we are the guests of the country in which they impose the rules, and then, of course, it's very difficult for us to influence the way they are behaving. But I am aware of what you are suffering, and I sympathize with you for that, and I hope and I expect more than the registrar is going to take care of insisting in that, so as the position of the Ministry of Justice and of the Dutch police is changed so as to give you a better treatment. So I would like, before I adjourn this meeting, to ask you if you have any other matters you would like to bring about now, please.
No, Your Honour, thank you.
Thank you, Mr. Kelly. What about the counsels for the defense? Do you have any other questions you would like to bring about? It is not that the... Oh, yes, Mr. Murphy.
Nothing, Your Honour, thank you.
Okay.
No, thank you, Your Honour.
If this is the case, we are going to adjourn this meeting.
All rise for your evaluation.